Welcome to Lawminds. Today we'll be seeing about kidnap and abduction. Kidnap and abduction are a very serious crime. When one person takes another person unlawfully against their will or without their consent to somewhere else, it amounts to kidnapping and abduction. So the motive behind it may vary, like or extortion of money or some kind of ransom, or for any other illegal activities like human trafficking or other illegal activities, etc. So IPC provides addresses both kidnap and abduction separately and provides punishment for both separately too. So first, kidnapping is unlawful removal of a person who is a minor. So basically it deals with child. Here minor means minor boy of age 16 years or below, and if it's a girl then minor girl of age 18 years or below. So kidnapping under IPC can be categorized into two types. One is kidnapping from India, another one is kidnapping from lawful guardianship. So kidnapping from India is when a person takes a kid beyond the territory of India without the consent of the kid or against its will, or without the consent of the person who has lawful custody over that particular minor. And the second type, kidnap from lawful guardianship, means when a person takes a kid from their lawful guardianship without the consent of the lawful guardian, then it amounts to kidnapping from a lawful guardianship. The first type of kidnapping is kidnapping from India, when a minor boy of age 16 years or below or a minor girl of age 18 years or below is unlawfully removed from and taken out of India, which means like taken beyond the territories of India without their consent or the consent of the person who has lawful custody over them. It amounts to kidnapping from India, and it is covered under section 360 of IPC. So there are two essentials here. One is the child should be taken out of India, that is beyond the territories of India. Second one is there should be no consent, like without their will or against their will or forcibly the child should have taken out of India by the kidnapper. The second type is kidnapping from lawful guardianship. So here when a person takes a minor boy or a minor girl from someone who has lawful guardianship over them, then that is kidnapping from lawful guardianship under section 361 of IPC. So there is an exception to this section. So when any person, if he believes that a particular child is his illegitimate child, then takes that kid away from his lawful guardianship, then that won't amount to kidnapping from lawful guardianship. And also if someone believes that they have in good faith, if they believe that they are entitled to lawful custody of a kid, then that won't amount to kidnapping from lawful guardianship too. So here also there are three essentials under the section. First of all, this section also includes person of unsound mind, not only minors but also person of unsound mind if they are taken out of their hands of their lawful guardianship. It amounts to kidnap under the section. So there are three essentials, like taking away of the person away from lawful guardianship and without consent of the lawful guardian. So punishment for kidnapping is given under section 363 of IPC. So a person who commits kidnapping from India or kidnapping from lawful guardianship shall be punished with either imprisonment of a term which may extend to 7 years, or fine, or both. So this provision provides punishment for kidnapping. And then let's move on to abduction and its punishment. So abduction, kidnapping is about taking away of a person who is of minor, but abduction applies to people of all age group. So under IPC, abduction itself is not a crime, is not an offense. It is not mentioned as an offense under IPC. But when abduction has been committed with certain intention, like to threaten or extort money or some other reason, then that amounts to punishment under IPC. There are two essentials for an act to constitute as abduction. One is taking away of a person from one place to another. Second essential is it should be of a forceful manner or deceitful manner, like they should threaten to come hurt the person in order to take them, or they have to decide them, like asking them to come because someone else they know is waiting there or something like that. So it should be in forceful way or deceitful manner. So abduction itself is not punishable, as I said before, but if it is done with certain intent as mentioned in section 364, 365 and 366 of IPC, which we will be seeing later, then it is punishable. So now we'll move on to penal provisions dealing with kidnap and abduction. So first, section 364 of IPC. So this section provides that if any person kidnaps or abducts anyone with intention to kill them, or has knowledge that they are probably going to get murdered by someone else and still kidnaps or abducts them, then that person is punishable under the section with imprisonment for life or imprisonment to a term of 10 years and fine. So next, section 364A. Here, if any person, this section is also similar to section 364, but the only difference here is the intention to persuade the government or a foreign state or any other individual to perform an act or refrain from performing an act or to obtain money. So basically, if it is to threaten government or foreign state like that, then that will come under section 364A. And for this, the punishment is a person who does that, kidnaps or abducts under section 364A is punishable with death or imprisonment for life or a fine. Under fine. So section 365 says that if any person kidnaps or abducts anyone with an intention to confine them secretly and wrongfully, then they are punished with imprisonment up to 7 years and fine. So let's say a person kidnaps a kid of 8 years old or 10 years old, or say any person abducts a major itself adult and confines them into a secret place and wrongfully. Obviously confining someone is violative of their fundamental right. No person has the right to confine someone without their consent. So if someone kidnaps a person to confine them secretly, then they are punished under this section. Next is section 366. Under this section, if any person kidnaps or abducts any woman with intention to force her into marriage, or has knowledge that someone else will force her to marriage, or force her into some kind of illicit intercourse, or has knowledge that she will be forced to have illicit intercourse with someone but still chooses to kidnap or abduct a woman, then such person is punished with imprisonment up to 10 years and fine. So next is section 366A. Here this section deals with a minor girl. Minor girl is a girl who is of age 18 years or below. So the minor girl, if any person induces the minor girl to go somewhere where she will be forced to have illicit intercourses, or has knowledge that she will be forced into such kind of situations, then that person is punished with imprisonment up to 10 years and fine. We would have seen in movies these kind of situation happen mostly in movies. So where a person kidnaps a minor and takes her to a place where she will be forced to have intercourse with someone, then those person are all punished under this section. So section 367 says that if any person kidnaps or abducts anyone, the kidnapped or abducted person will be put in danger or subjected to grievous hurt, slavery or unnatural lust, and still kidnaps them, then such person is punished with a rigorous imprisonment or a simple imprisonment up to 10 years and fine. So section 368 says that if any person, he or she has a knowledge that a particular person has been kidnapped and still chooses to wrongfully confide them, then they are punished as if they have kidnapped or abducted such person with intention to wrongfully confide. So this is a presumption. Law will presume that even though they did not kidnap, but they had the knowledge of kidnap and still wrongfully confided them, then the law will presume that they kidnap the person with intention to wrongfully confide. So what is the punishment for this? The same as same punishment given to people who kidnap or abduct other people with intention to wrongfully confide, which was given in section 365. So next, section 369. So here it was this particular section deals with kidnap only. So when a child who's of age below 10 years has been kidnapped with an intention to steal any immovable property from them. Say a kid is playing with his mom's phone. A kid is of 9 years old and he is playing with his mom's Android phone, and an adult sees this, and in order to steal that phone, he is kidnapping the kid itself. So such person is punished under section 369 with an imprisonment up to 7 years and fine. So we'll see some landmark cases that dealt with this particular subject matter. So first, Varadarajan versus State of Madras. In this case, the accused, he abducted young girl from her legal care with the goal to sexually exploit her. So Supreme Court in this case held that when a minor girl is removed from legal guardianship, which is kidnapping from legal guardianship, for the reason of sexual exploitation, then it not only constitutes kidnap, but it constitutes both kidnapping and abduction under IPC. And this case also clarifies the difference between the two crimes. Next is Srimati Suman and another versus State of Uttar Pradesh. Here, Allahabad High Court gave an odd decision. So, we know minor girl is a girl who's of age 18 years or below. So, and we've also seen a provision which says that if that particular minor girl has been kidnapped by someone or moved from one place to another by someone unlawfully, then that comes under kidnap. But in this case, it was held that if a girl, in this case the girl is of age 17 years old, yeah, she is a minor, but she was mature enough to understand the consequence of the decision she is about to make. So here the girl ran away with a boy from her lawful guardianship. So the court here held that she is 17-year-old girl, but still she is mature enough to understand the consequence and reasoning behind her decision, and still she chose to leave the custody of her parents to live with a boy. So here the boy did not put her under any kind of pressure, inducement and all. The girl willingly went to live with the boy. So you can this case said that the boy cannot be punished for offence under section 361 of IPC. So the next case is State of Haryana versus Rajaram. In this case, a person was detained against their will. So when a person is detained, we know it is violation of fundamental right, because Article 21 right to privacy says that anyone gives us right to move and right against detention also. So the Supreme Court highlighted that just keeping someone detained does not constitute abduction unless there is a plan to transport them against their will from one place to another. As I said before, abduction alone is not considered as offence under IPC. Abduction should be done with certain intention. Only then it constitutes as an offence. For example, a person has been abducted and there is no further motive, then that is not an offence. But if a person has been abducted and the motive here is to threaten his family or friends, to extort money in return, or it is to threaten someone else in some other way, then there is an ulterior motive. There is that motive or intention is like essential element when it comes to abduction. if there is no intention, if abduction is not combined with certain intent, then you cannot arrest a person under offense of abduction under IPC. Next is state of Maharashtra versus Chandraban Sudham Stanap. So in this case, the defendant was accused of kidnapping someone and carrying them away without their will. So the Bombay court emphasized that in order to convict of kidnapping under section 362 of IPC, the prosecution has the obligation to establish all necessary components beyond a reasonable doubt, because no one shall be punished for an offense which they did not commit. So it is violative of their rights, and it is violative of principle of natural justice too. So when prosecution makes a case that against a person, saying that person committed an offense, the burden of proof lies on prosecution to prove all necessary components beyond a reasonable doubt. They cannot establish doubt in the create doubt in the mind of the judge and say that and think they have done their part, because beyond a reasonable doubt is the important part here. So prosecution have the obligation to do that. And also another thing was also discussed in this case. Abduction and kidnapping both have a very common essential element, that is consent. So in both cases, kid or adult has been taken away unlawfully against their will or without their consent. So if the victim gives permission to the particular thing, they go with the abductor willfully, then they cannot the person who is said to be abducted them cannot be tried for offense of abduction, because there is a permission, there is a consent here. So next, Vishwanath versus state of Uttar Pradesh. In this case, it was held that in the case that if a person commits a mere abduction, like this is similar to the case of state of Haryana versus Rajaram. So mere abduction only was the intention here. There is no other ulterior motive. There is no mens rea here. There is no intent, other intent and all here. Then they cannot be said to have committed offense under IPC. So thus kidnapping and abduction are very serious crimes. After 2005, kidnapping and abduction have started increasing more and more, and so the government, Indian government, Indian legislation, judiciary from time to time pass judgment in order to protect people against such crimes, because these are not only kidnap and abduction and crimes like this are not only violative of persons' fundamental rights, but they are also a threat to society. So the IPC provides extensive measures to handle and punish these offences, and also these provisions are essential to protect the interest of individual fundamental rights and also safeguard the entire society on a whole. Thank you.